All right, so welcome to this month's Top Shelf. We've read The Last Trial by Scott Turow, and we are amazingly lucky enough and honored to have Scott with us for part of the session today. I feel like I don't have to introduce him, but I want to. He's not only one of the world's great writers, but also a world-class lawyer. And some of his insight about being a lawyer is what we're going to discuss today. His books, as all of you already know, truly transcend the legal genre, legal thriller genre. I'm on vacation now, and I'm in a cabin. I walked in, and of course, right on one of the books on the that someone had left here was Presumed Innocent, which was the second book I've read of yours, Scott. Of course, I read 1L before I went to law school, and it scared the hell out of me. It's not just that these are truly literary works that really move us in some way and speak to us as human beings, but they also are so insightful about what it means to be persuasive in the courtroom. Scott gives us these vivid, realistic experiences that can make us better lawyers. So we're going to have a chance to ask him questions, talk about some of that. Let's just take 30 seconds for Roland to come on and remind us how this works so that people can ask questions. So Roland, would you go ahead and do that?
Hello, everyone. For those of you who haven't been here before, we use the raise hands feature that's built into Zoom instead of the chat or the Q&A. So we're not going to be monitoring the chat. So if there's a question that you want to make or a comment you want to make, and John will ask for hands raised. So if you look in your panel now, you can find that hand raise feature. Just find it for a second, make sure everyone go ahead and push their button and raise their hand. And then on our end, we can lower it again after you raise your hands. All right, that's great. Looks like everyone found it. If your commentary is going to be extensive, we may bring you on camera. When we bring you on camera and promote you to the panel, it might take a second. It'll look like it's disconnecting and then reconnecting. So just keep that in mind. It'll reconnect and then you'll come back on. And then you may have to unmute your microphone, or you may have to turn your video on your end, depending on your settings. Okay, so that's pretty much it on my end. That's it. Thanks.
Yeah, and if you don't want to be on camera, don't raise your hand. All right, so Scott, we're so glad to have you. Do you want to jump right in with us asking you some questions, or you want to talk? Okay, great. We'll jump right in. So I'm going to start. So the first question I have for you is, when you were in trial, when we look at what you produce in your books, the insight into the key moments in the trial, and it made me wonder, when you were in trial, were you to some extent looking at what was going on in the courtroom through the eyes of a novelist for things that were moving or persuasive or impactful? And the reason why I'm asking you that is maybe that's a skill that we can all develop to try to figure out what works, what's impactful, what's moving in a courtroom.
I wish I was that cool, calm, and collected during the course of a trial. But, as all of my many trial partners could tell you, in that mode, I was at my most intense. And I was pretty much locked in to what was happening in the courtroom. I wasn't thinking, gee, this would make a good scene in a future novel or anything like it. I was all there. And I think, frankly, that's probably the experience of most trial lawyers. It probably doesn't make a lot of sense to tell people to back off and take a panoramic view, because they're not going to do it. And certainly that's not what your client wants. They want you all there.
Yeah, so that makes sense. And I guess for the rest of us, we have the opportunity to look at books like yours to learn from them with a little more distance than when we're actually in the courtroom. But let me just push you a little further. I mean, it really is remarkable. I don't see it in any other book that I've read. I mean, there's a couple we read, And the Sea Will Tell, with where Bugliosi, he knew he was writing a book when he did that trial. But it's very rare, I think, to to capture the moments that actually make a difference in a trial in the way that you do? I mean, do you have any insight about how you're able to, you know, tell us about those moments, even fictionally?
I have to go off on a tangent because I knew Vince Bugliosi well,
Oh,
and
wow.
and if you go back to that copy of Presumed Innocent that you raised and look in the flyleaf, you will find a blurb from Vince Bugliosi
Really?
in
I
there.
have forgotten that.
And the way Vince and I met was in the courtroom, where I was one of the prosecutors. I was the junior prosecutor on the prosecution of the sitting Illinois Attorney General, who was ultimately convicted of tax fraud. And Vince was basically his lead counsel. And although I thought I was intense in the courtroom, Vince took it up to another level. And he gave a 9-hour closing argument in behalf of the defendant. And any single moment of it was sheer brilliance. But going on for 9 hours may not have been. But you know, we remained friends till his death, and he was a great guy. So in terms of your question, which I've basically forgotten, the reality for all of us who try cases, especially those of us who had the experience of being prosecutors or federal defenders, where you're trying a lot of cases. A lot of that stuff just gets burned into your brain and your nerve endings. I mean, I really feel like I could make objections under the rules of evidence and cite case and rule, in my sleep. And so a lot of the trial process really is second nature to me. And after years and years of doing this, you'd hope that would be the case. So, anyway.
All right. So yeah, that gives us an answer, and then the rest of us can learn from your experience. Let me go ahead and open it up to questions. We have the way we usually work is we talk about some of those moments and discuss how they have the impact on trial. But I know people are likely anxious, since we have you here to ask some questions. So let me, if you have a question, go ahead and raise your hand. And while you're doing that, because it takes a moment to go through, I'll ask you a second question. I know you've said previously that writing a novel is in some ways like presenting a case to a jury. Can you tell us a little bit more about that?
I didn't realize how similar they were in tasks, as tasks, until I was a prosecutor, and I just sort of began to think about it, and I was like, wow, these two things are a lot alike, and I can learn a lot as a novelist from the way cases get presented in court. Because if you think of a jury as a cross-section of the popular audience, which is exactly what it is, then you can measure from their responses what works and what doesn't. You will not succeed, especially as a prosecutor or a plaintiff, unless you have a coherent story to tell. Motive is never supposedly part of any criminal charge. But the reality is, if you can't explain to a jury why the defendant wanted to do something that his community denounces as wrong and probably evil, you're not really going to get any far. So you've got to present a coherent narrative as a prosecutor. And how do you do that? You do it the same way a novelist does it, through the different voices and different perspectives of the different people who were involved in these events. And they're called characters in a novel and witnesses in the courtroom. But the prosecutor, like the author, is trying to meld all those voices and at the same time keep his audience from falling asleep. And to the extent that my time as a writing fellow at Stanford had educated me in a lot of highfalutin literary theory. My time in the courtroom really went to kick that out of me and prove that sometimes you don't have to be as original as Finnegan's Wake in order to succeed with the jury. And very often you're better off not trying to do that.
Okay. All right. Great. Thank you. All right. So I'm going to bring on Lee, Deborah, and Jim, the first three that raised their hands. We'll go with the first three questions, and then we're going to move on to some topics. So it'll take, again, to remind everyone, it takes a moment for people to pop up. It's a limitation of the technology. And why don't you, Lee, you go ahead and start.
Thank you, John. I appreciate it. Mr. Turow, it's a pleasure. Thank you so much for joining us. It was, I haven't completed your novel. I've gotten significantly through it. The question I had was that your novel addresses a legendary trial lawyer's sort of final legs, if you will. He's wrapping up his career. In terms of your coverage of trial law and the evolution of issues that are important for juries to consider, was that incorporated in how you had your protagonist approach the jury in this case? In other words, I know, I followed these books, obviously not for a while. Was there an evolution in his trial approach that's reflected in how he approached his very last trial?
Well, I think one of the things that Sandy Stern is aware of is that, you can only be yourself in the courtroom. And as he says, a jury that prefers style over substance is not his kind of jury. And so he's got some very complicated bodies of law to deal with, regulatory laws that affects clinical trials, insider trading law. And he takes it head on. He tries to break it down for the jury. And early on, he goes into the science in his opening remarks, and he thinks to himself, the jury is never going to really understand this, but it makes them recognize how erudite and important his client is, who's a Nobel Prize winning cancer researcher. And so he goes through it not because he's really trying to educate the jury, just because he's trying to impress them with the genius of his client.
I like too how Sandy, not just in this book, but the respect he shows for the intelligence of the jury. I like his kind of lawyer in the real world. All right, so Deborah, go ahead with your question, please. Deborah, you might have it on mute.
Yeah, there you go. So I just finished listening to your book, which was very well done. I liked the voices and was pleased to see Sandy Stern back. He's one of my favorite characters, Miss Raul Julia. My question is, like most of us, we're pretty good storytellers as trial lawyers. And I'll tell stories to, my colleagues and my family, and they're all like, oh, you should write a book about that. It seems like it's a different skill set. So how do you go about trying to translate your good stories into a good novel like you've done?
Well, one of the epical moments in my life was when 1L came out, and I'm standing in Harkness Commons at Harvard Law School, and 1L was really launched by a glowing review in the Daily New York Times by Christopher Lamenhaupt, who was then the Times book critic. And I'm standing behind two guys in Harkness Commons who are looking at the paper and reading the review, and one of them says to the other, I should have done that. And I thought to myself, you effing jerks, yeah, I could do that. I just didn't think of it. I could have, and I'm thinking, like, I spent 5 years at Stanford as a writing fellow and a teacher, and, I've learned my chops. It's writing fiction is like any other art. It takes practice. And the old joke about, you know, how do you get to Carnegie Hall? Practice, practice, practice. So yes, the native gift that most trial lawyers have as storytellers is of great use. But how you get it on the page, of course, requires some refinement. But, you know, I once had a wonderful judge, Tony Scariano, take me out to lunch. And he told me a really wonderful story about World War II. And it was a little bit like the plot of Three Kings. And these guys who'd stolen stuff in the middle of the war, and the murders they ended up having to commit. And it was an amazing story. Told me and talked nonstop for about an hour and 15 minutes. And he says, now how do I write that? I said, Tony, get yourself a tape recorder, tell it again, and ask your assistant to type it up. You'll have a hell of a start. So, and once it's on paper that way, you can also recognize what isn't working for the written form as opposed to the oral. And that could be a very good place for anybody to start.
Thank you. That's really helpful. Appreciate it.
All right, Jim, go ahead with your question, please.
Well, it's a big honor to have to be here, and I appreciate it. My question dovetails a bit with Deborah because you made a comment, and you may have just filled it in, but I was curious about path of how lawyer becomes author, and you've mentioned this Stanford training a couple times. Did that come before Harvard, after, and how'd you prosecute and attend Stanford writing training?
Well, I am not a lawyer who became a writer. I am a writer who became a lawyer. My ambition always was to be a novelist. And I pursued that as an undergraduate at Amherst College. I then won a couple of writing fellowships. One of them took me out to Stanford. As I said, I spent 5 years out there. And I was hired to teach as a lecturer in the English department, which gave me a foothold on an academic career. And I realized I didn't want to be an English professor. It's a great life for somebody who wants to do it, but it wasn't a life for somebody like me who just blundered into it. And I could have papered several rooms with rejection slips in those days for stuff I had written. So I knew I was going to support myself writing fiction. And the question became, well, what am I going to do to support myself if I don't want to take the path of least resistance and teach? And ironically, I had no idea what lawyers did because my father, as I like to say, was a prophet in his own time, in the sense that he was a physician who hated lawyers long before it was common for doctors to do that. And so he literally wouldn't let him in the house, except for his best friend across the street, who he forgave for being a lawyer. So I really didn't know what it was that lawyers did. And then all my college roommates went off to law school, became lawyers, and I thought what they were doing was fascinating. And I began to notice that the friends I was making in the Bay Area fell into two groups. Either they were other young writers around the Creative Writing Center at Stanford, or they were lawyers. And more often than not, they were criminal lawyers, whether that was prosecutor or defense lawyer. And I just thought, wow, this stuff is really, really interesting, and much more interesting to me than, English criticism. Or deconstructionism, or what was sort of the main meat of English departments in those days. And so I bought a book and studied for the LSAT and did well on it, and then turned down a job offer at a really good university in order to go to law school. And then, of course, I had to explain to my literary agent what the heck was going on. She had been trying desperately to sell this novel that I had written while I was at Stanford without any success. And, you know, I got in the middle of this letter saying, but, you know, I still want to be a writer, and it sounded really lame to me. So I gave her a for instance, which was that I had noticed that there wasn't a good nonfiction book that described the day-to-day experiences of a law student. And to my astonishment, she went out to lunch with a man named Ned Chase, who was senior editor at that time at G.P. Putnam Sons. And she showed him my letter, and Ned had written a contract for this book on the spot. So I ended up going off to Harvard Law School with a book contract. And as I say, to make new friends and to write about them. But I, for two reasons. One was because of that contract, but much more importantly, because I had taken my own measure well. I was fascinated by the law. I am still fascinated by the law. It gave me a subject matter that, you know, reaches deep into, you know, my viscera. So the great break of my literary career was going to law school. If that's not enough irony for you, I can't do much better than that.
All right, so we have a lot of people wanting to ask questions. Let me go ahead and take two more. I was going to cut it off and move to the topics, but let's bring on Kay and Jim. And if that's okay, Scott, we'll have two more direct questions.
Sure, and then I'll go, John, if that's okay.
Absolutely.
I think probably my questions have been answered in the last two, but what I wanted to say is that I also listened to the book on Audible this weekend. And what really struck me all the way through it is, as much as I've been a fan of your books, Scott, in listening to it, I was thinking about, I'm a personal injury lawyer. The closest I've gotten to a criminal case was I served on a jury, a rape case years ago. You found the essence of the things I feel in the courtroom. And I was so overwhelmed that somebody could express those things that I had not put words to. And so I've been so impressed with that ability. And I sort of had two kind of, I don't know if questions, but it was, so is this how criminal attorneys feel, like personal injury ones? Or have you blended different experiences? And I was curious if you were still a practicing attorney or not. And so I think you probably covered a lot of those things, and especially hearing that you were a novelist first, but you have done, I think, a spot-on job with the essence in the story. And that's what I wanted to say.
Well, thank you. When I left the U.S. Attorney's Office, I joined the law firm in which, as of today, I am still a partner. I will retire on the 15th of this month. So I will become a retired partner at that point. You know, I appreciate it. I tried a lot of civil cases too. But my feeling really is trial is trial. You know, there's somebody on the other side of the courtroom who's trying to beat your brains in, and a judge in between, you know, who you're trying to psych out and understand. And I think the moving parts are really the same, whether it's a civil or a criminal case. Obviously, in a criminal case, you know, the fundamental issue is really clear cut because somebody's liberty is at stake. And because you're dealing with a a subject area where there has to be proof beyond a reasonable doubt, or at least an effort to do that, it's got to be a little tidier than most of the civil cases that I tried, which were in areas of like construction law. And I represented a couple of brokerage houses. I did a lot of securities law work. And so to some extent, as I say, the issues in a criminal case are a little more compact, but trial is trial. It's basically the same thing, and just a really intense experience for all of us.
All right, Jim.
Thank you.
Thank you so much for coming on the program, sir. Two quick questions. One is, was it just serendipity that we're talking about last trial when now we have COVID and so many courtrooms are shut down? I tried a case in February, and it may be the last case I try for 18 months, 2 years, because they're experimenting with types of trials with virtual juries, and we see some of these things, but the volume of it is just not going to allow us to get back in there, particularly with criminal cases taking priority. That was one. Two, I love your books and your character development, but in this one, and maybe it's just because of my age now too, but the development between Sandy and Marta was really special. And it was something that you knew that there was such a connection there, both mentally and physically, as father-daughter, and how it was all put together. What inspired you to A, talk about last trial, and B, such a development between a father and a daughter?
Well, the books, although they're kind of tied together, are chronologically accurate. So Sandy Stern, when he first appeared in Presumed Innocent, was 52, and now he's 85. And the years pass in the fictional world of Kendall County just as the years pass in the real world. So I knew that if I was going back to Sandy Stern in the present tense, he was going to have to be 85 years old. And I thought, frankly, that was a worthwhile subject. It would give me the opportunity to talk about aging, which of course is something that I feel, and the more subtle issue about how you measure the value of a life. So I wanted to do that. Stern's daughter, Marta, was a character in the first novel I wrote about Stern, The Burden of Proof, which was published in 1990. And the fact that she was working with her father out of necessity. She'd come home because of the death of her mother and just sort of never left, and moved into her father's practice almost by accident. But the fact that she became her father's law partner has been referred to in some of the subsequent novels as the Sterns have passed by. And Marta was a substantial character in the sequel to Presumed Innocent. But that rhythm between father and daughter, I have two daughters, and some parts of it that the daughter takes no greater pleasure than in telling her father that he's wrong. Some of that is stolen from life, and some of it is totally imagined. I have a daughter who is a lawyer, but we do not. We've never practiced together. She tried one case and vowed that she would never do that again. She was just a wreck, so most of it's imagined.
Thank you.
Scott, thank you so much. I can't tell you how much we appreciate you being with us, and how much your books have meant to us. I've gotten a lot of comments from people about how much the books have meant. The little excerpt you have, I have printed it out, and it's on I'm not in my office now, but I have it on the wall of the office where Pinky's talking to her grandfather about whether life is fair.
Yeah.
And it's beautiful. And there's lots of moments like that in the book. So we just can't thank you enough.
John, thank you. Thank you all for listening to me. And I also take my hat off to you for your book club. It's a great thing to be doing. So thank you all, and have a good night.
You too. Thank you. All right, so let's leave Jim on. Might have been too late, but let's. Jim Bartemus and Peter Spillis have volunteered to help us kick off the first section of what we're talking about. Let me just tell everyone, we've been asked if we can have a website that allows us to discuss things between sessions, and that's in the works. We'll get an email about that tomorrow or Monday. I think it's done, so we can talk about the books between sessions, and I think it'll be a useful website for everyone. And one other quick announcement: in September, the first Thursday, it's always the first Thursday, we're going to be doing Just Mercy by Brian Stevenson. It's a very inspiring book, not quite as much trial lessons, but you will love it. And then we're going to have a second session, just a short session later in September, where we're just going to talk about the cross-examination of the coroner in presumed innocent. So we'll get that information out to you, but there's a lot to learn in that cross-examination. All right. So, and then, and the reason I brought all that up now is when, I know you get a lot of emails from me. So we're going to try to separate out the general scheduling emails from when I'm sending you an email. And one of the emails you'll get directly from me is whether you want to do a little homework to be prepared to talk about some of the subjects that we're going to bring up, like Peter and Jim have, and others as we go on. And at the end of each section of this, we'll still let everybody talk, but it'll give us a chance to get people on screen and do it a little more fluidly. So the first topic today is tactical communication. I call it the tactical and nonverbal communication, so you understood what I was talking about, because a lot of it is nonverbal, but it's not necessarily just nonverbal. So let me just, Bugliosi talked about it in the last book we read, and that was great. I think he talked about how he thought there were moments in the trial that could be won or lost based on that type of communication. Sandy Stern also uses nonverbal tactics to influence the jury. So before I ask Peter and Jim some questions, let me give you some examples. On page 20, Sandy suffered an objection, but it was overruled. And so Turow writes, Stern takes a second to offer the jury a smile of calm vindication. Also on page 20, just a moment later, Sandy wrinkles his mouth and narrows his eyes to suggest the government's decision is imponderable, disturbing. So I want you to think about that for a minute. He's in a constant state of communication with the jury that has nothing to do with what he's saying. So for Peter and Jim, what can we learn from this? Can we plan to communicate non-verbally? And if so, how would we do it? Will you script something out? I mean, how can we want to do it? Help us, give us some tips.
Well, I'll go first. I can't imagine being able to script out those non-verbals, although it sounds like Bugliosi probably would have said he could script those out, but I don't think many of us are him, But by the same token, I've never experienced a trial in which a good trial attorney didn't have some fair amount of nonverbal communication with that jury. We all, I think, tend to establish some sort of rapport, or at least try. There's going to be some level of at least meeting their eyes, and sure, when something is to be dismissed, you might roll your eyes. The trick, I think, the art is in knowing how much is too much, and what you can get away with or not. So I think that's, on first blush, that's my thought on that.
John, I think it has everything to do with communicating. And I think you can script some things like anchoring or mirroring, where you stand in the courtroom, how you gesture with your hands. You can practice that, and people can give you feedback on it. Some of it's natural. I think it's like raising our children. It's part nurture and part nature, and you learn it. But you know, there's so many things to nonverbal communication, and when you contacted me yesterday, I went back and just did a little research about trying to find out how all this came about. And there was a book written in 1872 that Charles Darwin actually wrote. And what it tells us is that there are universal expressions. And so all of this is part of persuasion to the jury, is our universal expressions. And as Peter talked about and smiled about, and you could see things in his mind that felt good to him, recalling a trial. We all project those. And I think some of that is just absolutely natural. It's what we do. Some of it can be, I think, filtered out, and some of it can be amplified, whether it's, you know, things like where we stand, how we stand, our posture, our eye contact, touch even. Do we point to things? Do we go up like this, or do we offer our hands? I think those kind of things that are all nonverbal are absolutely crucial to display in a trial.
All right, good. Yeah, so we're going to get into some more specifics from the book and take some comments from everyone else, maybe have some questions or disagree with you guys. Let me, though, kind of summarize here, because I think Scott Turow and Jim Bartemus, Peter Spills, they've all some commonalities in what they've said. So first of all, look, there's no experience matters. You know, there's no real substitute for it. But what we're trying to do is help younger lawyers who don't yet have that experience and help each other with experiences that we haven't had yet. So, you know, you'll get better at this. Some extent, you can't really script it out or train it. But there are some things, I agree, Jim, that that you can think about beforehand. And so I have just a quick kind of checklist people might want to write down. It's mainly things that over the years I've been scribbling down of ways I noticed that I or my co-counsel or opposing counsel damaged their case with a nonverbal communication that was hurtful. You know, like Peter said, sometimes you go too far. You got to be real careful that you don't get ahead of the jury. But here's just a couple of things if people want to write them down. Looking at the witness instead of the jury on cross, right? You tend to get into that argument. Prevents you from taking advantage of having a nonverbal commentary with the jury. So if you turn the lectern during cross, this is a preparation, right? It's not just experience or your natural personality. You turn the lectern so you're looking at the jury when you're cross-examining the witness. You're not looking at the witness. You're then you're forced in a way to communicate with your face to the jury about everything that's said. It lets you comment without speaking on everything that's said. On direct, it's the opposite. You want the witness to look at the jury. So if you move the lectern back behind the jury box, so assuming the judge will let you, now the witness is looking at the jury. You know, when you're on direct, you don't want to be looking at your notes. So make sure, maybe leave them at the table, because that implies that you're communicating that what the witness is saying is not important. Whenever the other side objects, I think it's a great habit to get into. Just look at the jury, right? It gives you a chance. They look at you. They're looking to see how you're going to react. Look at them. It gives you a moment, and you'll see. Sandy does that a lot, communicates with them on the objection. Do not, as Prosecutor Feld did at one point, light up a neon sign of desperate and futile objections right before damaging testimony. Okay, we all know that. You don't want to highlight the bad stuff right before it comes in. But the opposite is true too. You do want to wake up the jury with your posture and your tone before important testimony. You know, I talk too much about when I was a juror, but as a juror, we don't have the context. And so as lawyers, we have to give the jurors the context. When an important point's about to be made, with your tone, with your posture, you can communicate that something important is coming. All right, so those are just some things I thought it might be worthwhile. All right, so now I have a question for you guys, and then we'll take comments from everyone too on this. On page 20 again, and all these examples I gave you were all from the same page. So once you start reading the book from this perspective, Turow does such an amazing job of giving us all these details that we can learn from his trial lawyers. But also on page 20, Stern was talking in opening statement about the disagreement between Innes and Pafko. And, you know, just a reminder what that disagreement was. It was an affair between Innes and Pafko that Stern felt would be bad for his case. And he had it excluded with a motion in limine. So he says during opening that there was a disagreement, and he says the details need not concern us. And he offers a little wave of the superfluous. So my question for you guys is, because I think that's an important point, like this was, I assume that Turow or Sandy spent time thinking about this, because think of the delicate situation Sandy was in. He can't say anything about the excluded evidence. You can't talk about it, or then the other side is, it's going to come in. And but yet he wants to tell the jury there's nothing there, because the danger is that the jury's going to think something big is being withheld from them. So what do you guys think, Jim and Peter, of how he handled that? He doesn't, you know, it's not on the record. He didn't say, oh, that it's no big deal, right? Don't worry, that disagreement is nothing big. But didn't he say that in a different way? And what do you think of how he handled it?
I thought he handled it brilliantly, because it's just like you did, John, with your hands, just subconsciously, is that, okay, there may be something, but it's nothing. And we convey so many things with our body language and with our eye contact and with all of our nonverbal cues. He's first of all showing interest of telling this to the jury, and he wants them interested in hearing from him. So he's got a nice command about himself and how he stands and how he projects. And so they're going to believe him when he just goes, you know, and I think that was, I don't know if it was planned. It may have been. They had to think about it, like you said. But I think that it was really well done to say, there's nothing there. Don't worry about it. Let's move on to important things. Peter?
Yeah, and Jim, as you mentioned before, some of these little nonverbals can carry so much meaning, and those are things that can be practiced. And it's awful hard to object to a hand wave, right? But that one hand wave can really emote a lot of things. So those are the types of things we can work on, those little nuances, you know?
Well,
Yeah,
and it
that's a great
also,
point.
you know, it focuses, and that I'm sure that all the jurors saw that, and it draws attention to it,
Right.
that he's already established credibility, you hope. And if he has, and it's drawn attention to it to say, hey, trust me, this is nothing.
All right, so let's bring Alan and Jim on. Hopefully they're going to disagree with you guys, because you know how much I love disagreement. But let's see. We've got Alan Bernstein and Jim Perdue. They both have comments. Why don't we start with Jim, because he came off mute quickest.
Well, I'm an endless source of disagreement, so that's easy.
Good.
I'll be the ultimate contrary. So, and I know we've got a diverse audience, but and Peter, I don't know you real well, but Bartimus, you can do that. You can say, but there's nothing to see here. I can't say, but there's nothing to see here, verbally or non-verbally. Maybe when I'm a little bit older and have even more post
like this,
I can. But so I think that part of the character of Sandy, who obviously just from life experience I can identify, you know, at 85, there are nonverbal cues and credibility things that you have permission for if you do them in the context of credibility. But Peter made the point, you know, a lot of nonverbal communication is predicated on you being real. If it is very hard to plan nonverbal communication, because if it looks staged or planned, it becomes my cousin Vinny, where it's identical, right? And you don't get that. And so the point, John, on for example, smirking after having an objection denied. I had a jury punish me for my smirk when I was, a few years younger than I am now. Just said, you smirk too much. So what I thought was a knowing smile that I was winning, to them looked like George W. Bush in a debate. And it's just a reminder that when you're reading fiction, you've got to read it from my perspective on a forensic basis in the context of the character, because both Jim and Peter were already pointing out, it's a subject of any nonverbal is a subject of being real and the credibility that you're carrying in the room. And so planning it, and John, I have planned them. I've had moments where I knew the opportunity was coming, but the plan still was, from my perspective, something I could do, right? And consistent with what the jury was seeing in me. And so I would just challenge, I mean, Bartimus can do a Sandy Stern move. I could never do, but there's nothing to see here.
Yeah, so I'm just going back to look, because when you said smirk, Turow wrote, Stern takes a second to offer the jury a smile of calm vindication. But that's a good point. We maybe think we're offering a smile of calm vindication, but that's not what the jury sees. So, that's a good point. You got to be careful with all this. But again, experience helps you with that. I don't think that we should give up on it just because we can fuck it up.
But John, like all communications, and Jimmy hit it right on the head, it's like neurolinguistics. The meaning of the message is the response you receive. And Jim immediately got a response, I know, from if he thought he was giving a smile, and they interpreted it as a smirk. So it doesn't matter what you think you're doing, it's the feedback that you get. And doing nonverbal things and these clues we do every day with the people we're around, whether it's at the office, whether it's at home, we get that feedback. John, I'm sure your wife says, John, I know that look on you. I know what that means. And you haven't said a word. And so it's that kind of thing can be practiced. That can be learned, of how we project ourselves around others and get that feedback that's really helpful in a courtroom, that we don't do those things of which we've been criticized.
Yeah. All right. So another great point. We can learn outside the courtroom, right? Who we go into the courtroom with is who we are, and we can learn these things outside the courtroom. You got to do it. You're communicating nonverbally whether you intend to or not. So, I think you have to think about it. We've got Alan on too. Let me have him. He had raised his hand. Let's see what he has to disagree with you guys about.
Hi, John. How are you? I want to thank you. I'm actually my office in Hollywood, Florida. I live down here. I called your office a couple of times. They were very helpful, and I want to thank you for that. Very, very helpful with some things I had some questions on. But I wanted to go back to where you started talking about when you said you look at the jury and turn turn towards them, facing them. And I've tried both ways, and I do mostly DUI defense. That's what I've been doing for years. I wrote the book for Florida, but the point I'm trying to make is I try a lot of criminal cases, and a couple of years in the summer session up at Harvard at the National College for DUI Defense, which I belong to, F. Lee Bailey spoke. And F. Lee Bailey basically has a totally opposite opinion. He wanted, because he could do an hour cross-examination without looking at his notes. I can't do that. I don't have the memory. I used to be able to pick a jury and memorize their names before I got up as a second person and sound smart. Then at the end, mistake it on purpose so I wouldn't look too smart. But the point I'm making is I've tried both techniques. I've looked at the jury like you've talked about, because it forces me and I can make nonverbal. Then I've tried staring the officers down and just stare them right in the eye and cross-examine them. And most of the time they break at that point. I'm not looking at the jury, they break. But I break it down into chapter methods. And what happens is when I get to the end of the chapter where I'm staring at the officer in the eye, and I make my point, and it's a good point, then I'll turn around towards the jury as I'm asking the question and turn back. Otherwise, I see there's merit to both sides, and I'm still torn which way to go. And that's why I was glad to hear what you had to say. But what do you think about, like I said, what Bailey does and that type of thing? And because there seems to be two schools of thoughts on this.
You're saying that Bailey says he doesn't look at the jury. He's totally focused on the witness.
Focused, looks him in the eye, doesn't take his eye-to-eye contact, never loses eye-to-eye contact with him, and he drills him down until he tears him apart.
Well, Jim Purdue makes fun of me for this, but I'm going to say it again. He heard me say this at some event a year or two ago. You shouldn't listen to me. These guys are the greats. They know what they're doing. They're just wrong, okay? I think that's a mistake. My experience tells me, that's all I can tell you. My experience tells me he's wrong. Maybe he could have been an even better lawyer. He gave up a real opportunity to, and maybe he said that and he doesn't do it too, because we all don't always understand what we're doing in the courtroom. A lot of it becomes second nature, like Scott Turow said. But communicating with the jury when you're cross-examining a witness is one of your key tools, I think, in a trial.
No, I agree with you 100%. I try to do a little bit in between. Sometimes if I know I've got an officer on the ropes, I'll just stare him down while I cross-examine him. But I always want to look at the jury, because you're right. I want to see where the jury's going, because I sometimes need permission to attack them, because people look at that person with respect. And until I see the jury give me permission, I don't come out aggressive. I come out very calm, very low key until I get permission from the jury. And I do try to do some body language, but I see your point there. And that's why I asked you what you thought about that, because maybe it's just a guy like Bailey who has a photographic memory could do that. I have to look at my notes too at times. I can't do that.
Let's hear from Jim and Peter, and they can wrap this. I have the final point on it. What do you guys think?
John, I take Alan's point. One of our goals is to communicate with that jury and make that eye contact as we're cross-examining. But the primary goal is to break that witness. And you do need to focus in on them. So I think Alan's point is a good one. I think you focus in on that witness, and then you've got to find your times. You got to find your openings when you can look back over, check in with them, see how they responded to a particular answer. But I get his point completely about focusing in and having that eye contact and putting that witness under that direct pressure.
Well, John, I agree with that, Peter. And John did, though, sort of talk about the dichotomy between cross and direct. In direct, I'm like John, I'm in the back of the courtroom. I don't want to be anywhere around. I want the focus to be on that witness and what they're saying in the exhibits. On cross, though, I'm the one testifying, not the witness. If I'm doing the right cross, I'm testifying, and I want to be able to get the nonverbal. It's like Aristotle and the pathos. You want to know what's being heard, and the only way you can know whether or not the message you're giving to that jury and to that witness is by their reaction, by what you're seeing come back. And I think it establishes connection. I think it establishes trust. And so long as I'm in solid ground, cross-examining that witness, I'm going to be the one testifying right in front of the jury. I think it's very important to have that contact.
All right. Thank you, guys. So we actually had much more topics to discuss on tactical communication, but we're going to have to move on. We're going to do a 4-minute mixology session, limited to 4 minutes, and then we've got 2 more great sessions with Jim Purdue, and then opening up to everyone on closing argument, and then with Todd Falzone on the judge, and cross with Jim. Anyway, we got 2 great sessions left. We'll probably end at around 25 after. But in the meantime, we have our virtual bartender. This time he's in New York City. His name is Mac. He's going to teach us how to make a drink called The Last Word in 4 minutes or less. And this time we have volunteers on screen, Courtney Winston, Harold Pryor, and Chris Dove. They are going to attempt to make this drink. They volunteered. We sent out emails. They volunteered. We sent them the drinks, the bottles, so they should be able to do a good job. All right. Once they come on, we got 4 minutes. How you doing, Mac?
Hey, how's it going, guys? What's happening? Just going to introduce myself. Well, first off, thank you guys for having me. I appreciate it. I'm very excited to be here. Just a quick introduction. My name is Mackenzie Gleason. I work at a cocktail bar in the East Village called The Wayland, down on East 9th and Avenue C. It's a culinary craft cocktail bar where we generally take all of our ideas about food and great culinary ideas and infuse them into our cocktails. So today we're going to be learning the last word in 4 minutes or less. Now, before we start, I'm just going to go over what you guys will need. You need a jigger. If you don't have a jigger, you can use measuring spoons or a tablespoon. You're going to need your shaking tins. If you don't have a shaking tin, you can use a pint glass like this, mason jar. It's also great because it doubles not only as a glass, but a strainer, and also then your drink afterwards. Now, if you don't have a strainer, a Hawthorne strainer here, you can use a fine mesh tea strainer. For those of you that like to drink tea, even a big colander will do the trick. Other than that, we'll need obviously our Luxardo maraschino liqueur for anybody that wants to try their hand at making this after this is over. Some gin, some chartreuse, and of course, our juice. So let's get going. So everybody go ahead and grab their jigger if you guys have one. We're going to be doing 3/4 of an ounce for each part. The reason why we chose this cocktail is because it's a nice and easy recipe with equal parts, only 4 ingredients. So we're going to do 3/4 of an ounce or 1.5 tablespoons. You're going to go ahead and pour your lime juice 1/4 of the way down from the very top of your small portion of your jigger, and that will be 3/4 of an ounce. And go ahead and pour that right into the tin. I know you guys can do this, stick with me. After we do that, I'm going to speed it up here. We're going to pour 3/4 of an ounce of our green chartreuse. Right up there. Get that into our shaking tin. And then after that, we're going to take our Luxardo maraschino liqueur. Another 3/4 of an ounce, or like I said, 1.5 tablespoons. Right into that tin. And lastly, our gin. Now, after we get the 3/4 of an ounce of gin into our tin, we're going to do a shake. And we're going to do a hard shake. Now, for those of you that have some regular ice cubes out of your refrigerator, you're going to be shaking probably for about 7 to 8 seconds. Anybody that may fancy themselves as a cocktailian or a real at-home bartender who has some denser ice cubes, you're going to shake for about 15 seconds. So I'm going to be using a big cube. We've gotten all of our juices and our liquid inside of our cocktail. Go ahead and ice your tin. Close it shut, and let's give it a shake. Voila. Let's go ahead and strain it right into your glass. I'm not going to be using any ice on mine. If you have a mesh strainer, you can go ahead and double strain it. And that's it. You have a maraschino cherry, a Luxardo cherry next time, you go ahead and garnish it like that. Otherwise, voila. You guys have all successfully made the last word. Cheers.
Cheers.
Wow, thank you. How do they taste?
Mine tastes fantastic. I'm sure everybody.
Thank you,
Awesome.
Mac. But Chris, Harold, Courtney, how do they taste?
It's lovely. I have some cherries, but you guys were moving too fast for me.
Take out the future. Thank you.
Thank you, Mac.
Fantastic.
Appreciate it, guys. Thank you so much for having me.
Thank you, Mac.
All right, and thank you guys for volunteering. All right, so let's bring Jim Perdue back on, and we're going to talk about cross-examination, control, trickery, and theatrics. I'm not sure if I put that in the email, but that's how I think of it, control, trickery, and theatrics. So while we're bringing Jim on, I'm going to read to you an excerpt. It's going to take about 30 seconds, so it's a little longer than I like to, but there's 2 excerpts in the cross-examination section that I think are worth looking at in a little more detail. Across the courtroom, Stern stops to scrutinize Capek. He clearly enjoys being known as the great authority, but whatever his gripes with Turow, Bruno certainly doesn't appear to be slanting the data. Stern's sense is that if he solicits opinions from Capek, rather than challenging the ones he's offered, Capek will remain friendly. Lawyers are always taught not to ask a question on cross-exam to which they don't know the answer, but Stern's instinct is that there is an opportunity for the defense here. So would you say, as an epidemiologist, Dr. Capek, that there is a strong probability that Mr. Colquitt or anyone else diagnosed with stage 2 non-small cell lung cancer would live longer than 14 months? Capek pulls a mouth. I can't say a strong probability. A good chance, yes. A strong probability, no. It's all semantics, of course, but to me, a strong probability is closer to 85 to 90%. The jury doesn't get it yet because they have not been instructed on the law. Right now, this back and forth between Stern and Capek probably sounds like nitpicking. But if there is not a strong probability that the victims named in the indictment would have lived longer than they did, Turow could not have committed murder. You can't kill a ghost. Bottom line, the government's main epidemiologist expert has just testified, in effect, that Turow is not guilty. I mean, think of what you're going to do with that in closing. It's a monster moment in any trial. So how did he get a prosecution expert to testify that Pafko is not guilty? And so, Jim, I want to ask you about 2 points. First of all, he didn't know what the witness was going to say. So I want your thoughts on that. And then second, he pushed in the other direction. You know, he usually want a yes. He wanted a no to this question. So he pushed in the other direction. So tell me your thoughts on that, Kraus, because, you know, look, that could change the outcome of the trial.
So there's an interesting thing that he writes, and it's a telling moment that for those of us who have tried med mal cases, you'll find it in an adverse expert oftentimes. He says, Stern senses that if he solicits opinions rather than challenging the ones offered, Capich will remain friendly. Stern's instinct is there's an opportunity. And what the opportunity is in this cross is kind of it's not arrogance as much as I've seen in med mal cases, but it is in that this guy is the leading expert, right? And he wants to establish himself as the leading expert and as an authority. And so what happens in cross here, and I certainly have seen in whether it be a defendant, but certainly an adverse expert in the field of medicine, if you appeal to their ego, if the cross opens up for them to show how freaking smart they are, or how much of an authority they are, or how much they know about something, that question that you may not be in control of, right? But your instinct tells you that if he's scientific, right, and he's tied to the science, but he wants you to know how smart he is, and therefore he wants the jury to know how smart he is or she is, they will say exactly what you want them to say, because it's fundamentally based in them wanting to establish they're smarter, or they're the preeminent person. And to me, that's exactly what was exemplified by that. And it's just a play. I've seen it. I've run the play. Yeah, I've seen it run. It's a play on an academician's academic ego.
So he played on his ego. He was polite. He was willing to ask a question. He wasn't sure he was going to get the right answer. And so when you're trying to do what you just said, do you think there's an advantage in, you know, the exact question was, so would you say that there is a strong probability, like it seemed like he wanted him to say, yes, there's a strong probability. Like, do you think there's an advantage when you've got a guy like that who wants to be the smartest person in the room to kind of push him in the direction you don't want?
Well, so you've tried a lot of tobacco cases, and I know there's different issues, but in the medical malpractice context, the opportunity here, right, is there's lawyer words that don't match up with either the scientific or the medical terms. So in trying a product liability in a medical device case, same disconnect happens when you're dealing with an engineer or you're dealing with a material scientist. So if you get into, can you say that, can you rule out that the mesh is a producing cause of a tissue response? Well, no true scientist can ever say never, right? Almost any true scientist is going to avoid getting into the box of anything that is 100%. In this particular one, the code language from the law is strong probability, as I understand it from the book, on the way the charge would define kind of life, the expectancy, right?
No. Well, let me, because I've read it so closely on that issue, Jim, that the law was probability, right? In other words, would they have probably lived longer? He added in the strong because he wanted him to fight him. He wanted him to say no.
Yeah. Which is, well, so maybe I missed it, but he says, but if there was not a strong probability that the victim's name in the indictment wouldn't have lived, that may just be your narrator, right?
Oh, no, you could be right. I could be wrong about that, Jim.
Well,
yeah.
But what I love about it, right, is whether it's whatever the semantics are, the reality is that the teaching moment for me, and I think for anybody, is you can choose a word in legal terms that a scientist, from whatever field, is going to have a different meaning. And so don't define it for them. Because what happens is the scientist takes his or her definition, which may not be what it means, right? Because for him, all of a sudden, what he's saying is, to me, strong probability means 85 or 90%. Well, when we talk about reasonable person or reasonable medical probability, that doesn't get translated to percentages. But this scientist wants to say, well, that's what that means to me, and therefore I can't say it, right? And I think it's a brilliant semantic example of kind of the invitation for you to take what we know as legal terms, but it doesn't necessarily mean the same thing, especially to somebody who's smarter, because they don't think in layman's terms. And then it becomes the cross of, well, would you say, and they won't go to the charge. They won't go to the ultimate issue because in science, that means a different thing.
All right. Yeah. So I hope I didn't muddy the waters too much with trying to draw a distinction between probability and strong probability.
You're just smarter, John, and I want you to be the foremost expert on things.
Well, see, you're doing to me what Sandy did to the expert. I'm going to try not to fall in your trap. All right, so let me let you talk about one more example before we try to see if anyone disagrees or wants to talk more about it. Getting a witness under control. At one point, Marta, he mentions that Marta has a witness under control, and he shows the power of it. She says, has the FDA done that in the past in the case of medications that might cause anaphylactic response? Rob smiles with faint bitterness. I'm sure you have examples at hand, Ms. Stern. So, Jim, in other words, he knows the answer is yes, or he's going to say yes because he's afraid of what she's got. How do you get that kind of control over a witness?
If you're in civil world where there's discovery, sometimes you establish that level of knowledge or superior knowledge in deposition, right? Which is why every deposition is an imperative, especially on an adverse expert, because if you're going to be the cross-examiner of the same expert, I think you've got to make sure you establish at the deposition process, you're not going to fuck around with me when we get to the show. And so that's one thing. On superior knowledge in the courtroom, especially on something like this, right? that becomes a couple of things. Number one, as Bartimus already talked about, kind of your credibility, your persona, that you can pronounce the words right. You clearly are based in the science. You clearly know kind of on the subject matter. You can't know the field of neurology, but you can know the field of C5 complications and radiculopathy every bit as well as what you're dealing with on the particular cross you're dealing with. And what she does there, right, is since she's already established kind of a deep knowledge base with that witness, he just knows I'm going to get slapped. The other thing, right, is on a question like that, to me, and I can use this example like on prior testimonies, right, in a meso case, just a complete road hard hooker of an expert, but it had so much prior testimony, you need not even break it out. You just have binders upon binders of prior testimony, and you say, have you testified in the past? And you get that exact same answer. I'm sure if I have, you could point it out. I've done the exact same thing, right? And that's just a matter of establishing superior knowledge.
So there's two, I just want to pull out two things that you said. One was you establish superior knowledge, you spank them a few times and they start to realize you've got it. But second, you also mentioned another form of nonverbal communication, which is a stack of binders, which God knows what's in them, but you're communicating to that witness that something's in them. In fact, you know what? Let's talk about that real quick, because
I know you want to use the thing about the pamphlet in the folder.
Yes, isn't that great?
It's great, but I'm gonna be the contrarian about it.
All right, so I want you to disagree. It's much better. Well, I guess my camera's right there. Let me just set, because maybe some people haven't finished the book, so let me just set the stage for this. So I'm not going to read the whole excerpt, but Sandy wanted to prove that Innes had called a certain number, the civil attorney, and given the information to him. And so he pretended that he had her cell phone records, which he established about 30 minutes earlier that they existed, and she didn't realize they existed, but he didn't have them. And so he went over to his granddaughter, Pinky. He said, let me have your folder. She's like, what, are you senile? This is my rock pamphlet or something. He's like, just give it to me. So then she realizes, she gives it to him. And so Innes is afraid that he has the records. And then the way it ends is actually the prosecutor stands and says, may we see the document? Stern nods. Before I display the document, I will certainly show it to Mr. Appleton, but first I would like to know, and he asked the question, do you deny that you made a phone call in April of May and advised Peter Newchrist that G. Livia could cause sudden fatalities? Innes casts a look at the prosecutors, then at her lap, and says, no, I don't deny that. Okay, so I'm saying that's great. I love it. Now Jim's going to tell me why I'm wrong.
It's so it's a great dramatic flair. It'll make a good scene in the movie if they make the book into a movie. It's the two Air Force corpsmen in the back of the room during the cross-examination of Jessup, right? It says, well, we'll get to the logs. We'll get to the logs in a second. Check the logs. We'll get to the corpsman. Don't worry about it. It's the exact same thing. And I think it's complete horseshit to be able to do it in real world. I don't think I have been blessed to have a lot of fun, but that is a high wire act that is so easy for a gust of wind to push you off, that as bold as I can be, and I've done some stupid shit, that one scares the crap out of me, John. I don't think I would ever go up with a folder with a bullshit piece of paper in it and say, do you want me to show this to you? I mean, that's what he's doing.
Yeah. So maybe I have more experience getting spanked by witnesses than you. So, I understand the pain of it, but you know, sometimes it's a risk worth taking. And yeah, it is painful when, you know, there's nothing more painful. You go home, you don't sleep, the witness beat you. And, but he didn't do it right at the end of the cross, right? So if he could have gone on, if he had lost that moment, but maybe, yeah, I see your point. Maybe I'm succumbing to the cinematic unreality of it all.
And I think it underscores the idea that especially for Cross, there is a flair for the dramatic that lends itself to Cross, and you need to play on that. I think it makes for a great moment in a book, a great moment in a movie. I think it's really dangerous. I mean, if I will just tell you, if I've got a binder of literature and if I've got 50 articles on something, and I ask somebody, doesn't so-and-so say it with the idea that non-verbally there's a binder of shit, I know what's in all 50 articles.
So here's why I might be more comfortable with it than you are. And maybe not probably 70% of my cases are in Florida, or my trials are in Florida. So in Florida, technically the judge or your own expert is allowed to testify that something's reliable, and then you should be able to cross on it. But in practice, a lot of judges, if the witness, him or herself, doesn't admit that it's authoritative, then they won't let you show it to the jury during the cross. So what that has pushed me to do in practice, and I assume other lawyers do this too, is I have it, right? It's in some learned treatise, some medical textbook. I have it there. They don't admit it's authoritative. I want the jury to know that the book says it, even if the witness won't admit it's authoritative. So I pull up the book, I read the jury can tell I'm reading it. And then don't you agree that, but I never show it to the jury so I don't violate the rule. So because I have to do that in every trial, I'm forced to it because the witnesses won't admit it's authoritative. Maybe I become more comfortable with things that don't necessarily say what, that I don't know, I'm guessing at, and I'm
That's a great point, and it's a flair, and I would say it's also a reminder. It depends on the specialty, right? But it's the reason why I still maintain, and I buy Harrison's Internal Medicine if I've got an internal medicine. I like having the book. If you've got a textbook, because to your point on the cross, right? Well, do you agree? And it just looks cooler when you do it with a 1,000-page textbook in your hand than it does with a printout or, a 5-page medical journal article. And that's again the flair. This flair to me is a little too far into the movie realm, but I get it.
All right, so let's bring in Carl, see what he has to say about this. And if anyone else wants to comment on it, we'll bring you in now too. Raise your hand. All right, Carl.
Do you see me now?
We can.
I'm here at home.
What do you think?
Okay, I had a conversation back in the 90s with Larry Posner, who I think everybody knows Larry, or knows of him. I mean, he's one of the experts on cross-examination. And after that conversation, we use binder texts. I don't know if you all know what those are, but they're the best trial notebooks I've found. Well designed, love them. And I went out and bought me a purple. And that became Bubba, or Big Bubba. And in that purple binder tech was all of my impeachment material for impeachment by prior inconsistent statement. And when I was doing, it was a long time ago, felony DUI defense, and I had the cop on the stand, I'd start off with just rock solid impeachments. And Bubba was always on the farthest table away. I mean, it was as far away from me physically from where I was talking to the witnesses I could possibly put it without pissing off the judge. And I'd ask him the question, and he'd answer it. And I'd kind of look at him, and I'd slowly walk over and get Bubba and flip it open, and I'd do my impeachment. And I got to tell you, by the third time, when I started walking over to Bubba, that son of a bitch agreed with anything I said. So when I got into areas where I didn't really know, I'd say, now, you understand that this happened, right? You know, oh, I don't know about that. And I'd start to walk for Bubba. I roll my eyes at him and walk for Bubba. And man, that son of a bitch agreed. He was the second shooter on the grassy knoll. You know, so I mean, I think that technique, if you develop it correctly, witnesses hate being wrong in front of a bunch of people they don't know. They don't know these jurors.
I love that idea, the walk. I've never heard that before.
I put it as far away as I could. I had to go around chairs. I had to walk around my paralegal. I mean, you know, it took a while to get to Bubba. But the trick was, if the first 2 or 3 of these that you do are rock solid, and you know, you're doing a cop, you know, they got 20 inconsistent statements, you know, that you already know about. Of course, we get discovery in criminal cases in Missouri. You may not get that in Florida, Texas. But, you know, once he's been shown to be wrong, he's so trying to look like he's the expert. I mean, I swear to you, I never even got around my paralegal half the time before he was like changing his mind. Oh, no, that's right, you know.
All right, Carl, that's great. Thank you.
I mean,
We appreciate that.
I'm just saying that stuff can work if you develop it right.
Right.
Well, thanks,
all
guys.
right.
Thanks for
Thank
having
you.
me down on too. Bye.
Well, and Carl's talking about control there, right?
Yeah.
As well.
Yeah, and a way to get it. So, Jim, you got anything more you want to add on cross-examination before we switch topics?
No, John, this is awesome. I'm having a great time.
All right, great. We really appreciate it. All right, so let's bring on Todd Falzone. While he's coming on, the first thing we're going to talk about is closing argument. On page 258, Stern and Marta agree that she will introduce certain evidence without fanfare, leaving it to Stern in his closing argument to make what he can of these transactions. He has something in mind that he would prefer not to tip to the prosecutors now. So, Todd, the way I read that is Turow, or at least Stern, agrees with Bugliosi about that the case can be won in closing. He's saving stuff for closing instead of trying to use it in the trial. So the jury will hear it for the first time in closing. So what are your thoughts? Does Stern agree with Bugliosi, and are they right?
Well, listen, I think that you know, that depends on how your jury is too. I think that a large part of that decision is going to depend on what you're dealing with as a jury. If you've got an attentive jury that's really following along with you the whole trial, and you've gotten them, you know, you can sort of leave breadcrumbs for them, leave like a little bit of a hint or a trail at what you're about to do later, and they'll remember it, and you'll get them with that in closing. But if they're, you know, if they're not that attentive, if it's a long trial, if there are many things that are going to happen between, you know, the book trial lasted a couple of days. You know, our trials, unfortunately, the judges go Monday to Thursday sometimes, and there's holidays or there's breaks or whatever it is. And sometimes there's sprawling trials that last for weeks. I don't know that you want to save it. I think that, you know, at some point you want to save it till a point where the witness maybe can't hurt you anymore when you unleash it. But, you know, there are times when you're going to want to just repeat it several times throughout the trial to make sure that it gets the effect and the that you're really looking for.
All right. So, and this is a related question, but not exactly the same. You know, one issue is whether to save stuff for trial. You know, Bugliosi even said he wanted the jurors to say, "Wow, I never thought of that." But the separate, which you've answered, but your thoughts on, but the separate issue is, does closing matter? Right? Bugliosi feels closing matters. He took I never heard that, but Turow just told us he took 9 hours in that Chicago trial. So, so I think a lot of lawyers today think, you know, voir dire is the most important. Opening then sets the stage. By the end of opening, the jurors have decided who they want to win. It's all over by the time of closing. What do you think? Does closing matter?
I think that that my thinking on that has changed. You know, you and I have been trying cases now a long time. It's been almost 30 years, right? And so there was a time when I think that that people were open-minded and you could, you know, you could build your case toward closing and still change people's minds and convince them of where they were, of where you wanted them to go, and win the case in closing. But I think that over the years, I've seen it changing. And I don't know if it's because of the shorter attention span of most people that are on our juries, if it's social media, if it's, I don't know. I think I feel like it's becoming less important because people tend to be entrenched in a position early. And if you don't get rid of them in jury selection, you're not likely, some of them, you're not likely going to change their minds. You're just not going to. So I think that over the years, and a lot of these stories, you know, Bugliosi's trial was what, the 70s, right?
Yeah.
Yeah, the sea will, and the sea will, only the sea will tell, that's in the 70s, right? And you know, I think over time, even, you know, what we've watched with some of the lawyers that we, you know, were taught how to try cases by, you know, Shelley Schlesinger, Bob even, you know, has been doing it a lot longer than we have. You know, I think that the thinking changes over time. And, you know, nowadays, I don't know that I would want to, I mean, we're still going to go full bore and try to give the most amazing closing argument you could ever give in every trial, no matter what, right? But I don't know that you're going to, that you're going to, you know, shift off into the closing some things that you would otherwise want to be presenting throughout the trial on the thought that you're going to flip the jury in closing. It just doesn't seem like that happens often. I mean, what are your thoughts about that?
Let me bring in, because we got people raising their hands. So let me bring in the first two, Madeline and Rima. We'll bring in three. We'll bring in Lewis too. Let's see what they have to say. You guys are all muted. All right, Rima's unmuted, so you can start first.
Well, I agree with what you, hello, by the way. I agree with what everyone is saying. I guess you don't see me on the video?
No, we don't see.
Hold on a second. Okay, I agree. I thought I clicked it. I agree with what you guys are saying. What I also kind of disagree is I do think closing matters. I haven't done big cases to your caliber, but like the little ones I do, when you're going in kind of like on the 48, 52, it could go either way, which a lot of these trials are kind of hovering around there. And you really give a good closing and you organize the arguments that were your points that they might not have completely caught. I could tell you I've won cases that I know I won just because of how I tied it up in closing.
So let me just interrupt for a second. I agree with you. I that's my experience too. I feel like, you know, in cases that I've lost, I feel like I could have, I just didn't quite do it in closing. So anyway, for whatever it's worth, my opinion is.
And like here, talking about props, I remember one where it was just, the guy had 3 herniations and it was about an MRI and it was a silly pip suit, whatever. And they didn't want to pay the bill. I ended up winning that trial. And I remember standing up, you know, in front of the jury to say, because it was the MRI showed 3 positive findings in his lumbar back. And I remember going, not 1, not 2. And I started, you know, grabbing my back to show the pain in the back, but 3. And, you know, and when they saw, I mean, I did it a little bit better than I'm doing it now, but when they saw how 3 herniations and bulges in your back, and I'm pointing to them and I'm bending over, they got to see the visual of, my God, how could you not pay for that test? I mean, look at how it's hurting her up there.
So Todd, what do you have to say? What are your thoughts?
Yeah, and listen, there's, you know, there is a clear disagreement among, you know, very talented lawyers as to whether or not, you know, the most important part of the case is jury selection or closing. And I think it, you know, like I said, I think it depends on just who your jury is and where you're at with them, you know, so you got to be able to, you know, figure that out early and do what you think is the right thing to do with your jury. But
yeah, that's a great point, and we have lawyers, all types of lawyers here, and even non-lawyers on this. But if you have the burden of proof, if you're the prosecutor in a criminal case, if you are the plaintiff's lawyer in a civil case, you can lose the case in voir dire, in opening, with your witnesses, with their witnesses, in closing. You can lose it at any point. So every part is the most important part of trial, probably. All right, let me go to Madeline, and then we'll go to Lewis.
Hi, I wanted to address both points. The save for closing. I think there's a danger to it. And in one of my trials, the judge would not let me show, it was a tobacco case, the judge would not let me show all the tobacco documents during the trial. So a couple of really critical ones, I had to save for closing because he only gave me like 5. You can show 5 documents out of like 1,000. And the jury afterwards, I mean, I won the case, but the jury afterwards were angry. And there were, 2, we have 12 and, you need 9 out of the 12, and 2 of the ones that voted against me said, that wasn't fair to the defendants for you to bring that document in because they didn't have an opportunity to tell us their point of view or whatever. So, that's my caution.
I never thought of that.
Yeah, that's my caution on that. And the second part, I think closing matters, but not in the way of necessarily winning the case, but in arming your jurors, the jurors that are on your side, with the points that they need to make to convince the jurors that are not on your side. So I think it's really important in that sense, but you better have some jurors on your side, I think.
So Todd, what are your thoughts on that?
Yeah, listen, I agree. That's, we've always focused a lot on rebuttal for that reason, which is, you get to the point of rebuttal. I always try to save as much of my closing for rebuttal as possible. Depending on the judges, some will let you put as much as you want there, but some, have predefined limits in their head. But the point of for us, the rebuttal and the focus, at least for me on it, has always been to give the ones who are ready to fight for you the best possible argument as they're walking out the door. And, and no one can refute it at that point. The defense lawyers are trapped in their chairs and they're looking angry because, you just kicked them in the teeth with something that you really, really wanted to hammer them with, and they can't respond to it. So yeah, to that extent, I agree.
All right. So Louis, go ahead.
Yeah, just quickly, a couple of points. My practice is basically federal criminal, and it's in New York. But the answer to me is the closing starts in the beginning. It never is at the end of the case. So I'm closing as I start my voir dire and my opening and as I'm going through all of the witnesses. So saving it is not something that I really think works with the way that jurors think today. So that's the first point. And the second point is I think you definitely lose cases in the closing argument, but I think you can get a juror because you're working on that emotional impact and you are bringing out the reasons why that jury needs to care about your client and your case. And that's where I think we win cases in closing argument. So I am on the school that closings count, but they really start early on.
Todd?
Yeah, listen, what you're saying is the reason why, and John covered this earlier, that for pretty much the entire cross-examination of any person on that stand, and sometimes during direct, I'm looking directly at that jury the whole time, because that is my closing argument. I mean, I'm all the questions, Jim said it, we're testifying in cross. I don't give a shit what the jury or what the witness says.
Right.
They're less, okay, especially with these, with the experts that are, that are paid, to say whatever the hell they feel, the defense wants them to say. I got to get my, voice in their head, or else it's not going to happen in closing 2 weeks after I started a trial. If that's the first time they're hearing me, they got to hear me the whole time. So yeah, I mean, I'm, any cross and some of the important directs that I feel it's better for the jury to hear the testimony from me, even than the witness, I'm looking right at the jury the whole time. And that's part of it. So.
All right. Thank you, guys. Oh, go ahead, Rima.
No, just one. I agree with everything. It's interesting when you hear other points like Madeline and Louis and Todd. They just, bring out things that are all. That's why trials are so fluid, because what might work exactly in one, you might get a different kind of jury, different kind of lawyers, different kind of judges. They don't always work, and the facts are different and the witnesses are different. But I remember I had a trial where our expert was horrible. When he was on the stand, I'm not the one who cross-examined him, my co-counsel is, and I was just sitting at the table wanting the hole to the earth to open under me and for me to just fall in there. And I was utterly humiliated. But I did the cross of the defense expert in a deposition prior, which is what was used. And I remember I got him to make enough admissions that basically the cross is what worked, because I said, forget about our guy. I don't even like our guy. I mean, I just kind of just sit there and say, but their own expert. And I went through what their expert, and really I think that made the difference to save that trial, because if you didn't have a closing there, it looked like our expert was horrible. And nobody was highlighting the horrible things that the other expert really said the way you would in a closing argument.
Oh, right. All right. Well, I know that hole too. I've wanted to get sucked into it myself.
Did you? I was wondering if I'm the only one who's like earth opened up under me.
All right. Thank you, Louis, Rima, and Madeline. I appreciate it. Todd, do you have any more to talk about closing, or also we had wanted to talk about the judge and trying to stay on his good side. Anything else you want to say?
Yeah, that's more challenging. Sometimes we don't get to stay on their good side, and we don't have a choice. They're at us at the word go, and there's nothing we can do. But
yeah, so we don't have enough time to get into the full thing here. But what Todd's saying is, and I want you to expound on that. But Bugliosi pointed out sometimes you got to fight the judge. Turow says it's imperative for any trial lawyer to stay on the judge's good side, at least in the presence of the jury. Look, that's the general rule. But Todd, you can't always do that, can you?
No, you and I have together been on the bad side of many judges in a courtroom and had no choice but to just go right at them, because otherwise we're going to lose the case. At some point, you have to make a judgment that the judge is going to take it away from you if you don't fight. And we've had jurors who rewarded us for doing that, who have seen us fighting the judge, and it looks like, everyone's against us and our poor client, and they've taken care of us. So, it's a hard thing to do, and it's nerve wracking. I know I watched you go through a trial. I won't give any names, but where, you were literally almost at a physical war with the judge, and you had to do it, and it turned out good, even though you felt all along that you were probably losing the case, but it worked.
Yeah, it's you get experience with it if you have to do it, and by that point, luckily, I had experienced the trial you're talking about, but I had hoped, and this turned out to be true, if the jury sees that you're being treated unfairly, because if you draw that out in front of the jury, they don't like it. It's not, they're on the side of the judge when it starts, but if the judge treats you unfairly and they start to get that sense, they can come through for you in a big way.
Right.
All right. So listen, thank you, Todd, Jim, and Peter. Obviously, it was great. We had Scott Turow this week. Jim Bartimus has volunteered to send out, to give us some books on nonverbal communication. He's going to give to me, and I'll email them to everyone. Remember, we'll have a regular session first Thursday in September on Just Mercy. And then we're going to have a couple weeks later a short session just to go over that cross-examination. I can send it to you guys. Although presumed innocent, I'm going to send it to you because it's just the cross-examination. But we can learn a lot from that cross-examination. And I think that's it. Thank you, guys. This has been great. It's going far better than I ever imagined. There's a lot smarter people than me in the world. So and the people who made the drinks, Harold, Courtney, Chris, thank you very much.
Thanks, John.
All right. Thanks, guys. See you next month.